Educational Institute, and I'd like to thank you for taking the time to join us for today's presentation. Before we start, I'd like to mention a couple of housekeeping items. All attendees are in listen-only mode, but questions may be asked by typing them into the question box on the webinar toolbar at any time. Participation in today's webinar is worth 1.5 CCS credits, and points will be applied to your transcript within 2 weeks. Today's moderator is Ms. Lisa Gelsomino, President and CEO of Avalon Risk Management, a leading provider of insurance and surety solutions for the trade and logistics industry. Lisa has over 25 years experience in our industry and currently serves on the board of the International Transportation Surety Association and participates in various committees including the NCBFAA ISF Subcommittee, TSN eBond Committee, and COAC Bond and IPR working groups. Lisa received her MBA from the J.L. Kellogg School of Management at Northwestern University and is the corporate insurance license holder for Avalon nationwide. We're excited to have her moderate our webinar today, and without further delay, I will turn it over to her.
Thank you. And as you can see here, for some reason, Craig zapped out my picture and Steve. So I'm glad, Craig, you're the only one participating today. But no, actually, I want to thank Craig and Steve Lubel from CBP for joining us today, because I know they both have very busy schedules, and in particular, Steve is getting prepared for the Trade Support Network next week. But most of you should be used to Craig and I think this is the 4th webinar we've done for NCBFAA on ISF and different categories. So, but as you know, he is the main point of contact and program manager for ISF. He's been steady there since 2010 and is a great source of information and continues to guide that program really well, and thank you for being here, Craig. And we're going to give you a few updates on ISF. I mean, we've given you a lot of the updates on the revised enforcement policy, so that'll be kind of brief. And then we're going to turn it over to Steve Lubel, who is, as you know, a business owner for Cargo Release. He has great knowledge because he was formerly a customs broker, so like many of you, he really understands the CBP side of the business and how to look at things from a customs broker's perspective. So I want to thank him. I had reached out to him because, as you know, we had referenced in some of our prior presentations that the ACE Cargo Release was deployment was coming out in July and was going to be allowing a Unified ISF, and that seems to be a lot more interesting than the prior Unified ISF process. So that's what he'll be outlining for you today, kind of hot off the presses. And of course, as always, we'll address your questions during the webinar, and we'll provide written documentation and with answers to all those questions. So we'll go ahead and get started. So these are going to be ISF updates. Craig and I did extensive outreach over the summer to all of the top 10 major ports, and those were very helpful because in many instances the port personnel was also present. And so I think that really helped with the new enforcement policy and also helped communicate to importers. And I'll also give you some of the updates from serving on the NCB ISF subcommittee with Craig, who gives us updates all the time. There's a few that we'll share with you today. But most of you should be familiar with the time frame. And again, these are all those links to the documents. And as Craig and I were saying, unless you've kind of been living under a rock or maybe new to the industry, you should be familiar with the enforcement guidance that was given back in May. So really, if you haven't, I've provided a link here to the FAQ update that Customs did, as well as to the last presentation in Charleston that Craig and I did in August. It would provide you with more detail on that newer policy if you need it. But what I really asked Craig today was to provide us with an update maybe on the ISF-5 or the final rule. So Craig, maybe you can outline that for us.
Sure. So as most of you know, the ISF-5 is not being enforced right now through holds or liquidated damages claims. And that is because CBP too narrowly defined in its original regulation who was responsible for filing the ISF-5 in certain scenarios. And so we have sort of pursued aligning that language and making it a bit more with existing language and making it a bit more clear who is responsible. So that is going to be a notice of proposed rulemaking that is in draft and in review as we speak. So that's something that you should keep your eyes open for. It is a substantive enough change that there's going to be at least a 60-day comment period. I would expect 90-day, if we're being honest. please comment when you see it, and then once that is published and we've had an opportunity to address the comments, then ISF will move toward being published as a final rule. It has been since 2009 an interim final rule. The only bits that were interim are those flexible filing options. Everything else was adopted as final, but this change now to the ISF-5, this proposed change to clarify the responsibility and addressing the flexibilities, will be the changes in what becomes the ISF final rule. I don't have timelines on that yet. I would expect the NPRM, obviously we're not going to see that before the end of the fiscal year because that's done. But we should be seeing it soon, and then the final rule, of course, will be subsequent to that. Like always, if you have any questions with ISF, and we're probably going to say this a half a dozen times in this, but feel free to reach out directly to me. My email is at the end of this presentation, or the Security Filing General inbox. I monitor that, and I'm fairly good at responding. So anyway, that's about it on that.
Okay. So I don't think we, I think we did get a question that came in.
Yeah, so we've got a question now about should we continue filing ISF-5, and the answer to that is an unequivocal yes. If you are filing ISF-5, continue to file ISF-5. It is required by law. The enforcement is not happening right now in any way that will negatively impact your business, but it's absolutely appreciated that you are continuing to file those ISF-5s, and it's definitely helpful for you to get in the get in a lot of practice basically before CBP is going to come out with liquidated damages claims for enforcement.
And before we go on, I should just add that this is being recorded. It is a free webinar, so it will be posted on the NCBFA website as well as CBP website. And I know some of you may not have gotten a copy of the presentation, but you will, if you were on this call, also get a copy of it for your records. So with that, we'll move along. Okay, so some of you obviously know that the ISF enforcement is really managed at the port level. Craig really gives the guidance from headquarters. And there were a lot of notices that were issued at the time last year, and also after the revised kind of policy came out, there were a couple notices that were sent then. But of course, the most recent one, which most of you are familiar with, goes into effect, in fact, today. And it's an important one because LA Long Beach is the largest ocean port, represents a lot of volume, and they definitely had, you know, some compliance issues. But knowing that they had so much volume, they were looking at more of a phased-in kind of approach. If you remember, when ISF first started in July of 2013, they announced that they were only holding cargo and ISFs not filed 24 hours prior to arrival. And they were only doing that on full container loads, but then they started doing that on consolidated cargo. And then they moved the time frame out to 48 hours. And now, as you see here, they're moving that time frame out to 72 hours prior to arrival. There are some ports like San Francisco and Oakland that typically follow suit. I'm not aware of any update that they've made yet, but their compliance rate is also a bit higher. So it really depends on what the ports need to do. I know Seattle, Tacoma back in May, when the revised enforcement strategy was announced, they had switched to 5 days. But other than the West Coast ports that do have, you know, the tremendous ocean volume, you'll find that most of the other ports are really sticking to that 24 hours prior to vessel departure, which is the law. So I don't know, Craig, if you want to give any more feedback on that.
No, that's true. But to explain further sort of what the enforcement policy looks like right now is that the ports are instructed to look at those ISFs that they consider significantly late. And significantly late, the definition is intentionally fuzzy. It is up to the interpretation of each port because significantly late means something different to each port. But you can feel safe in this definition that significantly late is defined as having provided that ISF at such a time that you negatively impacted CBP's ability to target that cargo. So, you know, a lot of these timelines that, say, LA Long Beach and Seattle and Tacoma have come out with, if you have crossed that threshold, you can probably rest assured that you are going to be considered significantly late. So that's just a best practice. Obviously you need to get it in 24 hours prior to loading, but there's a little bit of flexibility there right now while we're in this continued graduated enforcement phase.
We also got a question that came in about this. The Port of LA Long Beach will be holding cargo 72 hours prior to arrival in the U.S. Will this be similar to the New York, New Jersey policy where consolidated loads will be able to be debanned and the compliant cargo can be released? That's correct. Actually, it was LA who first put together that policy, LA Long Beach. It was pretty much adopted by all the West Coast ports, San Fran, Oakland, Seattle. And in May, when the revised enforcement came out, New York, New Jersey also adopted it. And I think some other ports did as well. It really depends on their resource, right, Craig, in terms of whether they're able to do that?
Yeah, it's not every port that is going to have this capability with CESs and CFSs, but this is basically what Lisa said. It's basically what's happening today. We've got another question that's pardon me, relevant to ISF enforcement, asking if any do not load messages have been sent based on no ISF filed. If that has occurred, that has been an error, and we have attempted to correct that as quickly as possible. ISF noncompliance is on its own not enough at this time for do not load instructions to be issued. So at this point, do not load is reserved for ISF purposes for national security reasons. And I've said it 100 times, but I'm very serious when I say it. If you are seeing do not loads, let me know. Don't sit on that thinking that it's properly done. Let me know about it, and we'll take a deeper dive into it to see what the reason is. Because if it was just by mistake or it's a training issue, I will address that quickly.
We also have another question that came in here.
Yeah,
you want to take that
so
one?
another one regarding sort of port policy. Will there be a standard policy or procedure on ISF holds being released once the ISF has been filed? I will have to defer to the ports for each of the, they're going to have their own processes. So that is not something, there's not going to be a standard policy per se on that, because all ports are different with their resources and facilities. So not every port is going to be able to do exactly the same thing.
And another question also came in about the ACE progress reports. Can CBP make sure the monthly progress reports are available via ACE portal timely? I think there have been some recent delays. Do you have any?
Yeah, these delays are, it's technology, and so sometimes it's unforeseen, obviously, all the time, and just not perfect. Just like any computer system, sometimes when you update something, something breaks, and so and as much as we try, of course, we try to get them timely, but there's just been a few little technological hurdles in the last month and a half or so.
Okay, so the only other thing I want to point out is that LA Long Beach, as you can see here, mentioned in their CSMS message that they will also be issuing liquidated damages to repeat offenders. This is also new. They in the past were not issuing any claims. Even back from July, they were not one of the ports that started doing so. Even when the revised policy came out in May of 2014, they said they weren't going to be, but their new policy now, effective 10/1, they will be doing so. And I think, Craig, you'll have an update later on the status of liquidated damage claims. So we'll go on to the next slide here. This was some of the outreach we had done. We've get some questions about how the outreach is being handled by the port, whether it would be a phone call, email, letter, and I'll have Craig talk a little bit about this.
Sure. So, and we're not going to try to beat a dead horse here, because I know we've spoken a lot about the new enforcement since May. But this is a copy of one of the letters that has gone out to a late filer. It is language basically that was provided as a template by headquarters, and you might see version of this may be exactly like this if you are late, or any other ISF violation really, for one of your strikes. This is the letter that would basically tell you that you have had a strike. It could be a phone call, it could be an email. I would expect that almost always you will have the letter. The best thing to do is just, not panic. The letter does tell you that it's not a notification that you're going to be receiving a liquidated damage claim. It is just a sort of a courtesy to say, hey, there's a law that you need to comply with. Please comply with it next time.
And I know from working on the NCB FAA ISF subcommittee, that time I got it all out in one breath. The NCB FAA has been asking if the customs broker or the ISF filer could be copied on a lot of this outreach. Well, obviously, that is difficult if that outreach is a phone call. Some ports do prefer that. Or an email or letter. I do know that a lot of the ports, when we did our outreach, were copying the ISF filer because they do think that's helpful. But I think from customs perspective, they had to allow the ports to deal with that within their resource. I don't know if you have any other update from that in terms of what
that's exactly
Officer Landers has.
Yeah.
Okay, so I think that's really how it's going to continue. We're already about 6 months into this revised policy, and I think most of the filers, the importers, are getting contacted and getting notified.
Right, and these are all port-issued letters, so any record of them will be kept with the port. But they sort of, when they occur, there's national visibility for all CBP ports will see that this importer had a strike. So the port that issued it will have record of the letter, but all ports will see that something happened.
So there's some questions that came in about this. The letter is not copied to the ISF filer. I kind of already addressed that. We recognized, you're concerned that it might not get to the right people. We as the surety, we feel the same way. We don't get copied on them either, and obviously we all want them to know. But these are not formal claims, and so, it's really just an outreach at this time. So certainly I think that if you get a copy, somebody asked if you receive a letter as the ISF filer, because some of the ports are copying you. I know sometimes as the surety we get a copy of them. You definitely want to make sure you're forwarding that to your importer contact, because if they are not starting to comply, they will see claims. I mean, that's the whole point of this outreach, these 3 opportunities. And there are importers who just haven't been paying attention. They are repeat offenders, and they are seeing multiple claims being issued. So you definitely want to keep on top of that.
And if you get this letter, it does not mean, we've got a note here, the letter, if you receive a letter and the records show that an ISF is on file, what steps do we take? It could be that you're receiving a letter because it was late. The ISF may very well be on file, but the timeliness of the ISF was the violation. And so the violation type is what you need to pay attention to, and that will sort of tell you what steps you need to take. If there's no ISF on file, obviously you're not going to be getting this letter because there's no, we have no ISF importer yet. But if it's late, which is most of the time, this is the violation. You just need to speak to your importers and make sure they tighten it up. We've also got questions regarding the environments where ISF will be implemented. ISF is statutorily confined to the maritime environment and will not be changing, so it's not relevant to land borders or air. And let's see if we got anything else.
Yeah, it says, are the letters sent via regular mail or certified mail?
Yeah, they're just regular mail.
Is record of the letter being sent kept at headquarters or at the port level? It's actually at the port level, right?
Yes.
Headquarters doesn't get copied on that.
And just to clarify, and this is a good question, this is why I actually don't like the 3 strikes language, because in baseball, on the 3rd strike, you're out. This is, you get 3 strikes, and then the 4th is when you're exposed. So the 4th strike may result in liquidated damages claims. So you do get genuinely 3 strikes, and then that 4th time is your first exposure.
Yeah, I originally referred to it as 3 warnings,
yeah.
But it became this 3 strike
Everybody
policy.
uses
Yeah,
that language.
so that's why you see it there in quotes. But yeah, not the formal name for it. But we get a lot of questions as the surety, what would we do if some of the warnings are not correct? That is, certainly possible, and I think the main reason for that is typically because of the bill of lading match. If there's a bill of lading mismatch, CBP will definitely see that ISF is filed late. So, and if it's not corrected before the cargo arrives or addressed in any way, there could be a warning issued, and sometimes we've had the filer is able to come back and show how there was a match. Sometimes it may have occurred before CBP's, or I should say a match occurred after their targeting. So there could be sometimes a delay in terms of when they're looking at that, but that is something then you can address in the petition process to clarify. So for example, if 3 warnings were issued and they issued a claim on the 4th time or 4th violation, and one of those warnings was not valid, you would petition on that 4th claim that 4th claim should be canceled in full because they still, it should be considered maybe the 3rd warning and not a claim. So those are all things that you can bring up in the petition process. And so part of your best practices would be to work with your importer to make sure they're tracking, what outreach they've received. And then you as the filer, once you know that the importer has received these 3 warnings, you can go back and look at your records and make sure that everything is in order to help them in any petition process. And we as a surety would do that as well. So there's another question that came in. Do you recommend petition at the warning level or waiting until a liquidated damage claim is received? You actually can't petition the warning. It's not a valid or formal claim yet. So you have to wait until liquidated damage claim is received. And my point is that you definitely want to at least look at what those 3 prior warnings were so that you know that that claim that got issued on that 4th violation is valid.
Yeah, and I'll clarify one thing. If you have not gotten your bill match message, once it matches, it won't be that it looks late to CBP. It will be missing until that match occurs. And so it will look like you've not filed an ISF at all. And if you wait, especially in getting into these time frames like what LA, Long Beach, and Seattle and Tacoma have talked about, you're going to probably find yourself wrapped in the process that someone who just did not file an ISF would be wrapped into. So you just want to monitor those disposition codes and make sure that you've got the bill match message.
And also just going back to the question in terms of, however the outreach occurs, please keep in mind that this is being tracked in a database,
yes.
CBP's database, that everybody can see. You can even see at the headquarters level.
Yeah, everyone can see the violations. And so if you, made a mistake in Newark, LA Long Beach tomorrow is going to see that if you are arriving in LA Long Beach with some cargo, LA Long Beach will be able to see that this importer had a late filing or an inaccurate filing in Newark yesterday. So it is a national view.
And then that's what you review too, Craig, right, when you get in a claim to make sure that...
So it's not actually the same system that I review, but it's, I do, at this time, headquarters is still reviewing all liquidated damage claims requests. So prior to the liquidated damage claim actually being initiated, headquarters is reviewing them to make sure that they sort of rise to the level that we expect.
And that these 3 warnings occurred.
Yeah, and that the 3 warnings have occurred. So the question also has come up about these letters, like do they expire? This 3 strikes regime, as we're going to call it, expires on May 13th, 2015. We issued this new guidance on May 13th, 2014, and it was for just a 12-month period. So after that, there will be no more letters, there will be no more 3 strikes, we'll be into just ordinary enforcement.
And I think another question came in to about the bill of lading matches.
Yeah, so there's scenarios that happen with carriers sometimes where the bill gets changed and you had a match and then you didn't have a match and then you had a match. It will not be late. The ISF was filed. The issue then becomes, of course, matching to the correct bill of lading number, so you just want to make sure that you get that correct bill of lading match. You're not going to be changing the ISF, of course. Just change the bill of lading number, and you want to make sure you get that match before arrival, but it would not be considered late.
Yeah, and I do know Dan Myler is on this call, and he's part of the NCBFA ISF subcommittee. And there are some challenges with M1 right now in terms of when the carrier is changing the bills of lading and not getting updated. So that is something that they're working with, I think he said Bill from CBP, to try to get resolved, and that should really help. But again, to the extent, like I said, I had a customer send me a warning letter that they had received, and it was a situation where the bill of lading just got matched, I guess, after CBP had kind of already targeted this importer for violation. So they were able to actually go back at the warning level stage to go back to the port and tell them this was issued incorrectly. So you can certainly do that, work with the port. It's not a formal petition, but if you've gotten copied on a warning letter and you know it's not valid, you're best to reach out to the port at that time and correct it before they even get to the fourth violation or issue a claim. But then you would have to address it through the petition process.
And a perennial favorite question has come up, how is CBP measuring vessel departure date and time? The ISF reports from the ACE portal show each vessel departure time is 11:59 p.m. Now, those are mile-wide lines that I'm asking you to read between, but CBP is measuring the timeliness of the ISF from the date of sailing minus 24 hours. So you'll notice that I did not say date and time. I said only date. So the date of sailing minus 24 hours. And so this is a much more generous position to put you in. You've got more time to become compliant. And so this is why you are seeing that 11:59 date or time for all your vessel departures, because we are basically giving you 11:59 of that day. So if you left it, if the vessel left at 1 a.m. on that morning, you've got 23 hours extra to comply.
There's a few more here. Do you want to take those?
If you have an ISF accepted, but the AMS shows no bill on file, will that be penalized at the same rate? Yes. So the no bill on file is this is the bill match, right? And so just because you have an ISF accepted message does not mean that you are complete. You have not finished your ISF. You need to get that S1 message, the bill match message. So that will be, if you continue all the way through to arrival to show no bill match, that is going to be an inaccurate ISF. That's a $5,000 liquidated damage claim.
Right, and then I know this is a common issue. We've had ISF not on file and received confirmation it was, did not get notice from customs that it was on file until we transmitted an ISF again.
Right, so this is a question that I will answer. I apologize that we're not going to get a satisfactory answer on this, this webinar, but to the question asker, we will be discussing this in the written responses later. It's a little too technical for me to hack my way through, so I will get information out there, and then once this particular situation is actually resolved, it's not an unknown problem, there will probably be a CSMS or some other kind of communication to the trade as a whole, so you can better understand it.
Okay, so we have a couple other questions, but I think maybe if we move along, we might have some answers on these next slides. So maybe you want to talk about the current volume of claims?
So obviously we've been in the liquidated damage phase, the new under the new regime since May 13th, 2014. And since that time, like I said earlier, we are issuing or reviewing at headquarters prior to the issuance of the liquidated damage claim. And so far, CBP headquarters has approved 63 ISF 10 violations. This does not mean that we will see, or that you will see, 63 liquidated damages claims, but these are ones that headquarters has said, yes, support. If you decide to move forward with a liquidated damage claim on this particular violation, we support that action. There have also been 4 liquidated damages claims approved for the carriers for stow plan violations.
And just to clarify that, as you know, Craig mentioned how he does the review to make sure that this is a valid claim, and then it's gone through the whole revised kind of regime. and then goes back to the port and says, okay. So the port still has to take the initiative to go into their system and issue the 5955A that you're all familiar with. That does get sent to the surety, does get sent to the ISF importer, and does get copied to the filer. The data has gotten a little bit better to where now our paper 5955A actually references the correct transaction number. We thank Craig for trying to help with that, because Customs was referring to an internal number that nobody understood. The challenge we have is that we still don't get it in our surety data, and as the surety we get daily downloads, so we can see claims right away, but it takes a while for the paper 5955A to catch up. So sometimes we may notify you of a claim, but if we don't have the paper 5955A yet that has additional detail on it, that's really where we can start getting into the petition process. There's been some questions here.
One that I'll address just is without even sort of reading the question, but just remember that ISFs are sort of imminently and infinitely amendable up to arrival in most cases. If you've used one of the flexible filing options, you've restricted your window of amendability up to 24 hours prior to arrival, but if you've just used an ordinary ISF, it is amendable up to arrival, and this is for any of the data elements and without fear of violation. So just bear that in mind. And then I know, pardon me, that the Northwest, we've had lots of labor issues with Vancouver in Canada, and a lot of cargo has been sort of unexpectedly diverted to Tacoma or Seattle, sort of a decision made by the carrier rather than the importer. CBP takes a common sense approach to ISF enforcement and understands all of the scenarios involved here. The ISF will be required, but we will understand and certainly appreciate that all of these will be late. So those kinds of things, this common sense approach will continue. That's not just for this particular scenario that we've experienced in Vancouver, but basically for anything, any kind of diversion scenario, the circumstances, the whole picture will be considered.
So we outline here the types of violations that we're kind of seeing now in this revised policy. I mean, these are definitely late ISFs from what we've seen. Literally, the cargo arrives and there's no ISF on file. That's not a non-file, it's a late file. So that's either the scenario, and there's been repeat violations of that, or in longer voyages, for ports that have longer duration voyages and are following that 24 hours to vessel departure. We're not seeing just a day late. We're seeing, significantly late. And again, situations where it is impacting CBP's kind of ability to target the cargo. We did already see a claim for a bill of lading mismatch, which is considered an inaccurate ISF, and I have this in quotes here. This is what the 5955A said, that it had an inaccurate bill of lading match at time of discharge. So basically, the goods arrived here when Customs is going to clear, and there's still no bill of lading match. That is problematic, right, because CBP cannot see that ISF. It appears late. In this situation, they only issued one claim. Remember, this is the situation where Customs could technically issue two claims, one for the late ISF, two for the inaccurate ISF, right, so up to that 10,000 max. But we haven't seen them do that yet, and in this scenario with this bill of lading mismatch, we're still in the process of kind of getting all the documentation together to see if we can petition it and prove that maybe the match occurred earlier. It's been too early for us to know, but that is something that we would look at. And then we get a lot of questions about what are other situations which would be an incomplete or an inaccurate ISF. I know, Craig, you've been vocal about how those flexible filings have to be updated to a complete transaction before 24 hours prior to arrival. So that would be something where that would be inaccurate or incomplete, I guess.
Yeah, it's an inaccurate ISF.
Okay. And a lot of people ask us questions, well, what about the comparison of ISF data to the entry data? Are there going to be claims for inaccuracies there? Do you want to maybe give your...
So it's not, there isn't a de facto comparison of ISF data to entry data, of course, because ISF is security only and not used for entry purposes. Steve later will talk about, these are ordinary ISFs. But in the case of Unified, that scenario changes a little bit. But if you're in the ballpark, you know, the ISF is a 6-digit HTS. If you're in the ballpark of the 10-digit, you know, we're not sweating that. That's not going to be the issue. The issue is going to be where if the cargo is examined for another reason other than ISF, or maybe another ISF problem, and we see on the entry that it's machine parts and it's, you know, cotton pants on the ISF, now where we have wholesale changes in the commodity, these kinds of changes will probably begin pointing to inaccurate data on your ISF.
Okay. So, I think just briefly, I had already talked about the petition process, and just for your benefit here, we kind of summarized the ISF mitigation guidelines that you should already be familiar with. But what we saw initially when claims were issued before the revised enforcement policy, we did see CBP petitioning all claims. They initially got issued for 5,000, and most of them were mitigated down to 1,000 for that first-time violation. In cases where the importer, and even in some cases where the filer was CT-PAT certified, we saw a 50% reduction, so down to 500. So I think that will continue. I see no reason. I guess the concern really is now with the revised kind of enforcement policy, you are going to start seeing some of those repeat importers who didn't take things seriously get multiple claims. And so that comes down to then, after that first violation, the minimum mitigation is $2,500. So it does, kind of stack upwards quite a bit. And so an importer really needs to take it seriously. If they haven't been filing their ISFs timely, they really need to start doing so because those claims could start racking up if they have a lot of violations, right, Craig?
Yeah, and I'll just, I know the question comes up quite a lot about the escalation in the liquidated damage claim. It's very different to how it is in entry. ISF is a security program, and this escalation was by design. It was not meant to ever become, sort of just a cost of doing business. So that's why you see that escalation. It does cause people to take it more seriously, and so as you see, these are your exposures. Before we move too far on, I wanted to clarify something. A question came up right as we were switching slides about the ISF data and being disparate from the entry data. There isn't a statutory requirement that they match. It's going to match naturally most of the time, but if they don't match, that is not an ISF violation. So, if you have two, like the ISF importer on the, or the importer record on the ISF being different from the importer record on the entry, barring this being a unified filing, that is not an ISF violation.
And we also got a question that came in about the withdrawal or deletion. Actually, this is kind of just an abbreviated version. If you link on, you see that mitigating factors, it'll take you to the actual mitigation guidelines. But that is really, there is a provision if an ISF is not properly deleted, right, because or withdrawn because the transaction no longer took place. So that is why that is referenced there as a potential violation. We haven't seen any for that reason, but it is in the guidelines. Okay, so I guess, Craig, you want to just give an update on your statistics?
Yeah, so this is just a quick and dirty on the 2014 statistics. This is from January 1st. We're seeming to hover around 2,500 filers year to year, so that number doesn't really change too much.
And we still see about 80 to 85% of the ISFs are filed by the customs brokers, right?
Yeah.
Okay.
And then so far this year, we've got about just a bit more than 248,000 importers of record for the ISFs, and we have received so far 8.4 million ISF 10s. We've gotten about 1.5 million, 1.6 million maybe ISF 5s, but we didn't include those in these numbers because the enforcement is only for ISF 10. But that's where we are. We're on track, just about I think a little bit better than last year's performance. I think we'll see roughly 11 million.
Right. So this next one shows you last year there were 10.5, and yeah, I think so far this is going to be a larger year, and obviously that's because enforcement went in place July of last year. What is the compliance rate that you're seeing now?
Compliance rate's in the low 90s. I'm not really breaking 92% on a day-to-day basis, but it's vastly improved over where it was in July of 2013. And so I thank all of you guys on the line for that. But yeah, it's I think we can do better. I'd like to see this in the 94-95% range. But everybody, I'm very pleased with the compliance rates.
And we also have gotten a lot of questions about eBond. As I've mentioned in all the prior presentations, 99% of ISFs are covered by the continuous bond, and they are in scope for eBond effective 1/3/2015. So basically any new Activity Code 1 bonds that cover both entry and ISF will be an eBond if they go in force. And actually all of the existing continuous bonds that are on file now will be grandfathered in. They're already in ACE, so everything will be electronic going forward. But the singles, even though there's not a lot of them, this is like the third largest bond type, so Customs does want to turn those into an eBond as well, and I have some updated information for you on that. And then this is kind of the same slide that we have gone over in the past about this ACE cargo release. I won't go into detail because this is something that Steve is going to cover. He's been waiting patiently. I'm going to give you an update about eBond for ISF, and then we're going to go into this ACE cargo release that kind of allows you to, handle this unified ISF and release.
And before we go further, I do want to address a question that comes up often, and it's always a little complex when we're talking about mother vessel, feeder vessel relationships, and some curious vessel routings where it's one vessel that hits multiple foreign ports before coming to the United States. The best way to think about ISF timing is when the cargo is loaded on the vessel that is coming to the U.S. So in a case where the vessel might travel from one port in China to another port in China and then to Charleston, let's say, that ISF must be, if it is on the same vessel that left the first port in China, when it arrives in the second port in China, and then that vessel is what arrives in Charleston, then that cargo that was loaded in the first port in China was due 24 hours prior to it being loaded in that first port in China. If it left the first port in China and went to a second port in China and transshipped onto a new vessel before coming to Charleston, then it is that the timelines are set by the departure from the second port in China. So I know it is it comes up in every outreach, and so I can appreciate that it is a complex scenario, but it's in mother vessel, feeder vessel relationships, it'll be the mother vessel always that establishes the timeline for the ISF.
Thanks, Frank. Okay, so very briefly, this is just a shot of our portal. Of course, every surety has their own portal, and every surety will need to, go live with eBond come January 3rd, 2015. So unfortunately, it still kind of needs to be a two-step process. We were kind of hoping that maybe we could integrate more like we do for entry, where the entry and the bond could kind of be filed or integrated with ABI and sent electronically and matched. So most of you, there's a small number of ISF singles being issued today, so most of you are already going into your surety's portal to issue that, and that'll really just continue. Basically what you do now, you would go into the surety system to get that unique bond reference number that you could transmit with your ISF to get your unique ISF transaction number, and then you would come back into the surety system to put in that transaction number. And then basically, as you can see, the way we do now, it's really just seamless. Basically, that bond gets transmitted, but instead of that paper bond, we're just going to be sending all the data elements on that bond electronically. And you'll be able to continue to see that status update within Merlin. And as I mentioned, there's really no integration with ABI or ISF vendors at this time. That doesn't mean it can't happen later, because obviously eBond is just coming out in January and as a pilot, and not all entries are going to have to be filed in ACE until November 2015. So there will be further enhancements that will be made. But for right now, that's what will take place with eBond. Now, we do want to point out that when you're issuing a separate ISF bond versus a bond for the entry. As you know, that's a different activity type, activity code 16. And the ISF importer that obligates the bond prior to vessel departure cannot be changed or amended because that's when the bond obligation begins. Even if the ownership changes, and always have to be mindful that the ISF importer may not always be the importer of record on the entry in this type of scenario. Now that's going to differ in a unified situation that we're going to talk about today. In this scenario, the ISF importer of record must match across from the ISF to the entry. That's why it's unified across the transaction. So most surety portals allow you to issue this type of bond already because it was issued on the standard 301 bond form. As you can see here, this is just a snapshot of our system where you would come in to enter an activity code 1 single entry bond, and then it would give you a choice to issue it as a unified. Our system would automatically add $10,000 to that bond to cover the ISF transaction, and in the eBond world, it'll actually then transmit that bond electronically for a match. So I think we've gotten maybe some questions that have come in, or no?
It was a follow-up to the question earlier about the vessel hitting 2 ports in China, and the short answer, of course, this was a question about when the carrier AMS is due. The ISF mimics the 24-hour manifest rule in its timeline, so it's exactly the same. The carrier would be filing for 24 hours prior to load in port A in China, as well as whatever is loaded in port B in China.
And that same kind of time frame is going to apply in a unified situation as well. Yeah,
that doesn't change.
It doesn't change. So here again, just a snapshot of showing you how currently we allow you to kind of email a bond, because you can actually today process a paperless entry for a single transaction bond in ACE. And now with this new release, you could actually do that for ISF as well. You could do a completely paperless process. We previously were emailing the bond. Instead of that, we'll just be transmitting the data elements. So it's a pretty seamless process. So with eBond, though, we do want to mention some updates and that are going to be forthcoming. With eBond effective 1/3/2015, the ISF submission types 5 and 6, which allowed the late ISF 10 or 5 without a bond, those will actually be eliminated. Because in the eBond world, everything needs to have a bond on file, and ISFs are required to be bonded, and so this was only a temporary provision and will be going away, and most likely you will see an update to that CSMS message that was issued previously. This is just a snapshot from the FAQ, so you'll probably see about 30 days prior a notice about that. Now, fortunately, the revised enforcement policy that was implemented in May, it actually eases the burden of this being eliminated quite a bit, because the ports were advised to issue claims within 6 months of the violation. So we will, even for like some of those one-time importers where once we go into full enforcement, you're not sure if Customs was going to issue a claim or not, at least we have a policy in place now to where we could look at, was a claim issued within that 6-month period, an ability to kind of, close out the exposure. Now, I will say that that doesn't absolve CBP's right to go back 6 years. The statute is the statute. All litigation, if you want to sue the government, is subject to that 6-year statute. That will never change. What we were trying to address here was that ISFs don't liquidate. And absent of that, what could be done to give some certainty to when an ISF claim may be seen? So that is why that policy was issued by Craig to the ports to issue those claims within 6 months, and try so that people could have some comfort that these claims weren't stacking. Okay, so every surety will have to manage that differently. Most sureties, do hold on to collateral for about a year, even when are involving entries. Certainly in a situation with a unified entry in ISF, that would be our policy. But I think within that time frame, we could definitely know, looking at the circumstances, is this a high-risk cargo or whatever the case may be, to consider the collateral. And certainly now, through May of 2015, most first-time violators with this 3-strike policy are not going to see a claim. So even with this going away, for your importers that didn't know. It's a first-time importer. They didn't know about ISF. Their cargo arrives. If it's the first-time situation, they're not going to see a claim, and that policy helps. So, Craig, we just asked you when 5/13/2015 comes around, what are we going to do about those one-time importers? Maybe you can give us some guidance. It looks like some questions have come in. It says, what happens if importer won't pay collateral for the late ISF bond? Well, that's certainly their choice. I guess they'd have to abandon the cargo if they can't get a bond. But I think you'll find that most sureties will be flexible depending on the situation in looking at smaller amounts or holding that collateral. And some of the importers, will just have to be mindful of this come the first of the year, that they will have to get a bond to bring their ISFs in.
And this is a good place to remind everybody that there are a lot of these importers who are maybe less savvy, are importing personal effects or household goods or very low value cargo. And there are, by policy, some exemptions to the bonding requirements for ISF, and often these importers' shipments will fall into those categories. So, the informal ISF, anything, the cargo valued less than $2,500, and the household goods personal effects ISF types are not bonded transactions. And so there really is no obstacle to filing late in that, you won't face this collateral situation for ISF, for the ISF bond, but it will still, if they don't comply, they'll still find themselves jammed up with, their cargo being held and release being withheld until the cargo is, or the ISF is provided. So if that's the scenario, just remember that those cases are out there where you may actually be able to file the ISF without a bond legitimately.
And that's all outlined in the FAQ. There's a link to it here that you can go to identify those transaction types, commodities and values, right? Yeah. So I don't think it's going to be as earth-shattering as everybody thinks it will, especially come the first of the year. You still have this provision through May where the one-time importer is not going to have 3 strikes. So sureties can contemplate that in their collateral. If you have an importer that's going to have repeat violations, well, they're probably going to see a claim. And so that is a situation where maybe they will have to provide collateral or at least show a financial statement to show that they have the wherewithal to pay their claims. So those are kind of the circumstances. But that's going to vary by surety, and you really have to verify that with your own surety. Okay, so I will go ahead and I think turn this over. This was my last slide. So eBond and ACE, this is not an eBond webinar, so just to be clear, if you want more information, you can go to these links and contact some of the CBP people who are working on the eBond module on the CBP side. And I know there's a lot of outreach planned the remainder of the year until that goes live. But what I did want to do is turn this over to Steve Lubel, who again, his picture is missing. Sorry, Steve. Are you still there?
Hello.
Yes, you are. All right, are you ready?
I'm as ready as I'll ever be.
Okay, so you have Steve's contact details here, and we'll try to figure out what happened to his picture. But
well, thank you, Craig. I'm either a square, I think out of the box, or I never fit in the box to begin with, but I appreciate the way you represented me.
Yeah, I am getting assigned blame for this, but I don't know what happened here.
What can I tell you? I'm happy with it, though. It's easier on everybody. So good afternoon, everyone. And before I get started, I know Lisa said a lot of nice things about Craig and I, but we have to say a lot of nice things about Lisa. We spent a lot of time with her over the last week or so, and she takes great notes, pays great attention, and really has been an advocate for making sure that the NCBFA is getting the right information in this webinar. So if you can't hear the applause, you should be getting it, Lisa.
Thank you.
This first slide we're looking at is where to find the latest draft documents. Now, I'm not sure everybody who's on the line is familiar with the ACE cargo release, what was formerly known as simplified entry. That is the ACE version of entry, rather than the ACS version, legacy HI transaction. This is the SE transaction. And the first document is the CATER chapter. It's also referred to as an IG, or implementation guide, just in case you hear people slinging those terms around. The second document looks really serious, but literally it is the error messages you'll get back when you forgot to put in something important like country of origin, or the bond is not on file for the importer of record that you've listed. And as Lisa was bringing up just a moment ago, with eBond, we've got all the bonds grandfathered into the system, and we'll be validating that not only does this importer have a bond, are they an authorized user on a bond, and we'll be looking at single transaction bonds coming up instead of having a piece of paper. As she was describing and showing some of her own firm software for Avalon, they will transmit in the same data elements that they send in on the piece of paper, and CBP will validate those same elements, but they'll do it in split seconds to the system, put it on file, and we'll align that up with the entry and make sure that it's there prior to processing the entry. So in these error codes, as we'll go through another slide coming up, these are basic things that will help not only you, the broker, you go back one please, but they're going to help the software developer and the vendor and the client rep say, oh gosh, it's very obvious what's not here, what should be here. And for the development team, I have a basic rule. We never want to hear a question. We never want you to have to open a help ticket. That between the error code itself and this document, it should be clear enough to find the problem and go address it. You know, because we've all suffered with this over many decades and been very responsive, but it's nice if you know immediately what the problem is so you can get business going. The next document is equal to the RR response that you get today. What's the notification? What's the status? Is it released? Is it paperless? Is it documents required? Is it intensive exam? This is this document and what information comes out inside of it. These are the latest drafts with the latest information, and they include modes for air, ocean, truck, and the unified entry and ISF filing. The last document listed is the ACE ABI batch and block control. Those are your headers and footers of the transaction, which essentially identify the filer, the port, and the electronic routing back to the location that the information is coming to and from. And these are ACE transactions. ACS had different control records. So we're moving all in this direction, and you should make sure when you're getting in to start to process and start to code for ACE cargo release that this is part of it. So let's go to the next slide. Some considerations. Some of these things you've just heard Craig and Lisa talk about. Why is this new? Well, it's actually not new, all these things you see here. ACS, the legacy entry, for some years has had available to file a unified entry in ISF. But of course, at that time, and it's still true today, that entry won't be processed until 5 days out for ocean, or appropriately if it's closer in, like from the Caribbean. So there's not a lot of people who ever use that particular transaction. With ACE cargo release, if you send it in 3 weeks in advance of it even being manifested by the carrier, CBP will process that entry, run selectivity, And if there's a question about an invoice, ask you about the invoice. You'll be able to go back and forth and resolve any questions prior to it arriving, so there's a much greater chance that that freight will be released, or you'll have a decision that it needs to be examined when it hits the port, and your logistics is going to go quicker and smoother than waiting 24, 48, or 72 hours later when there's a back and forth with CBP. And this is important because for the first time you can send it with confidence way in advance of the vessel departing or the vessel even considering loading. And that's the first consideration bullet point. Even though entry, you can do it up to 15 days, calendar days after arrival, the ISF portion is still required a generous 24 hours prior to vessel departure. Thank you, Craig. That was a great explanation of the times, by the way. Now, we know that ISF is for security and a security filing, and CBP has told the trade in writing and otherwise that it is not directly compared to commercial admissibility data from the entry. So if you have one party who's filing the ISF and another is importer of record, that's what it is. So the Brokers Association and CBP and others have discussed for some years, is ISF customs business or not? As I jump around a little bit here, the fact is that when you file the entry and the additional elements you also need for ISF, you've just filed your entry. And all of the information is available in one transaction. You do file the HTS at the 10-digit level because it is entry. And the conveniences you're about to see is that we take this in one envelope as if you mailed in two forms in the same envelope. And as soon as we get it in-house, we use those same data elements and we create two separate records exactly as if you had transmitted them to separately, one for entry and one for ISF. And that means that the brokerage community, the importer, has a better opportunity to see consistency. An overwhelming number of the ISF transactions are filed by brokers. Now, that doesn't mean that the broker has all the information for entry 24 hours or 3 weeks prior to loading, but it's a start. On CSI and the 24-hour manifest rule, everyone knew that the information existed, but how much pain and suffering would it take to get it that much in advance? And it went much smoother than most people thought it ever could. And here's another opportunity to get things going earlier, to file your entry, even eventually certify off summary for entry in ISF. We'll be going in that direction as well. So when you file this unified ACE cargo release in ISF, it is customs business because it's the entry you're filing. It will be seamless to the point that once you file it, you'll get a response back for the entry. You'll get a response back for the ISF just as if you had filed them separately. And in the benefits, you see you can take those three-step processes down to a two-step, which would be entry in ISF, and the second step would be summary. You've got that common data as to one shipment in your own system. You've got that ability to clear these shipments earlier, know and recognize issues earlier in the process, and avoid that delay. And as we move forward, the ACE single window, as we add in the other government agencies. Again, a consistent set of data where everyone's looking at the same thing, and the software-wise, data-wise, it's a tremendous benefit. It doesn't mean it's the only way to go, and doesn't mean it's cheap. We're smart enough to know that, but it is an opportunity for people to take a look at. Can we go to the next slide, please?
Yeah, Before we do, Steve, I don't know, there's some questions. I don't know if you answer them later on or if you want to...
Oh, let's take them now.
Okay, it says, how does this work for FTZ facilities?
Well, we not getting to that yet, but I'm happy to answer that question. We will be doing something similar with the FTZ. I mean, you can do it today. The E214 does have the facility, pun not intended, to take in the ISF data as a unified filing, but as far as we can tell, no one's ever used it. And we will be carrying that forward when we start to process the electronic admissions in ACE instead of ACS. And I hope that answers the question.
Okay. I think I'll go ahead on to your other slides because some of them...
Oh, but I might as well, down in the weeds, it's always dangerous to ask me a question, that there is no importer of record on an admission. So there is a separate ISF importer than there might be of the operator of the FTZ. So we'd have to handle that in a separate conversation.
Okay. And we'll get the questions and we can always answer them that way. Okay, so I'm going to move to your next slide here.
All right. So let's talk about the Unified ISF and cargo release data elements. These look very familiar. These are things you do every day. They look like the ISF. We've got importer of record number, consignee number, and please notice the name and address all through here, including for the manufacturer. And these parties, if you're not familiar with the ISF and you're not familiar with ACE cargo release, you've got importer who is taking the responsibility for CBP, taking on the obligation for the information that they report. They're taking on the obligation for duties, taxes, and fees, and other liabilities, which is never a problem for Lisa because her bonds are never cashed in, so it's wonderful.
Right.
And the consignee is who it's meant to go to, I mean, on whose benefit it's meant to go to, but the seller is not necessarily the person who shipped it, is not necessarily the person who's involved. They could be a third party, but this is a party who's part of the transaction in post 9/11 with the importer security filing. We want to know who is actually selling these goods and who's actually buying it. These are all the parties involved in this transaction. And the ship to party is a physical name and address where those goods are expected to be delivered, the first point in the U.S. The manufacturer, which would be the MID, this is true for the ACE cargo release as it is for the ISF. Instead of an MID, which was already outmoded with duplicates with that algorithm 25 years ago, we take a name and address. And no, there's a general question. If you take this on the entry, what about entry summary that still takes MID? And the answer is internally, an MID is created from that name and address and should match up to what is on the entry summary, which really isn't a problem software-wise. In a broker's software, if you're using an MID, you obviously have a name and address and vice versa in the same file that you can use in both places. Country of origin, commodity at the 10-digit level. Then you have the container stuffing location, and that is a physical name and address, and the consolidator, the stuffer, name and address who handled stuffing it at that location. And then the bill of lading number. Now, it can be a regular bill, what us old fogies used to call a master bill that didn't have any houses. Or if it's a master bill, that means in today's world it has children. It's a parent and child relationship. So CBP wishes on the importer security filing the lowest level to be reported, that would be the House bill, and there would be a corresponding master as a reference to that House bill, or the regular bill. But you have to mark it as regular or House. If you were to list only master bill, as in M for master is not really what they use, CBP would say, no, 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 that's not going to work. Where are the children? Where are the houses? Where are the details? And you still require to match this up to actual bills of lading. Let's go to the next slide. I see we're already at 2:12. I'll try to pick up the pace. Now, Lisa, I want to make sure we do not go back to the last slide. And when people send in a chat note, do we see the name of who's sending it? Lisa?
Yes.
Good. Here's the challenge. This is a unified filing that was put in today in the development environment, and I've marked it up, showing the separation. If you see on the right, everything at the top is the regular ACE cargo release entry. On the bottom is just the additional records for the additional information that's not found on the entry that would also be required to satisfy the ISF filing. So the question is, while I'm speaking, which is a lovely drone of a voice, what's missing? Why would this filing be rejected? All right? So let's take a look at the top. You see they've got the importer of record, and that's
we have an answer on it.
We have an answer?
We have a couple, yeah.
Who came first?
One is loading place.
Uh-huh.
And the other one is no stuffer.
Nice. And who's our winner today?
So the first one was Brian Hunt.
Okay, and who's the other?
John Marshall.
Very good. Take notes of those names for me. Congratulations. I'm very pleased that y'all were paying attention. That's an excellent point to that. And I'll get right to that. If you take a look at the top on the left, I'm using my finger so everyone watch my finger here. The record starts with SE10, and that's the first record in an entry. And you see that, thank you. You see the highlighted importer of record number. These are not true information. If anybody out there has this number, congratulations, you're a winner. That is the importer number. And you see on the bottom it's repeated in the SF10 record, if you point to the bottom in the ISF record part, only because that record requires certain bits of data, including who is the ISF importer. And the way we design this is part of our agile push, and in general to be efficient, not to write unnecessary code that would have to be redone later and later and again in different places. But what we've done is any information that's already being processed, say for ISF, we left the ISF-10 as it needs to be read by that other system, so we wouldn't start confusing people. So the bottom is the ISF importer of record. The top is the importer of record for customs purposes. The third line down, you see SE. That is the seller, name and address. And then you've got the buyer. Then you've got the ship to party. And then you move down to the SE40 record by where it says the red with the CEN. And on the SE40 record, if you go a little to the right, you'll see another CN. That's for China. Over to the left. There we go. Up a little, you see a CN next to the brand name watch model. And then we've got, it is the consignee is the SE50 record, showing it happens to be the same consignee. Then we show the manufacturer, name and address. Then the 60 records, there happen to be 4 of them. So this is very important. There are 4 tariff numbers right here. Please note that when you file a unified filing, it must be 100% of that bill of lading. In order to satisfy the ISF for that bill of lading, you obviously must be filing all the information for ISF for the bill. So you can't have two separate entries for the same bill where you may not be declaring all the tariff numbers and all the information for that bill. I hope that's clear enough. And what we're going to do for the ISF is we're going to take all that information in the entry records on the top half of that transaction, and we're not going to make you repeat it on the bottom where those SF records start. So it wasn't required, so we do the FS10, which tells us the ISF importer. You see the SF25, and those happen to be the container numbers that are involved. And if this was properly done, you would see some SF30 records, some 30 through 36 sequences for the consolidator and the stuffing location, because those weren't listed above. They could have been listed. They're optional for the entry. But since they weren't there, we would list them below, and we would automatically make a record for the importer, the IM, also, and we would take this information, and with that header and footer, the control records, we build an exact ISF 10 and send it to the system that does the ISF processing, just as if you sent it in separately. Meanwhile, you've built it and you've sent it in once, and you know that you sent in only one set of tariff numbers. You sent in one set of bills, one set of manufacturers, and you know exactly what you've done. Let's go to the next slide. And here's the responses on the entry side. For a ACE cargo release, you have an SX response showing that the data was accepted for the entry. You have an SO disposition. That this disposition actually shows on the third line from the bottom, no bill match, because we don't see a bill on file for that yet, because I didn't manifest this, which is appropriate because it was done in advance of manifesting, even before loading. And in a different webinar, and I've done one of these before, we could do again, we talk about how ACE cargo release works. But your ISF response would be normal. A common question we get is, what if I file this after the vessel departs? What if I file it 2 days before it arrives? What if I file it a day after it arrives? From a technical standpoint in software, we're going to process it without any prejudice over Craig Clark coming to visit you with some of his big friends. We'll process it, we'll put it on file, and all other checks and balances will be in place to say, gee, I didn't see this happen before that vessel arrived. Can we go to the next slide? Do we have some questions? I've got lots of information.
Yeah. So there was a question that came in, what happens if you file the unified entry and it has to be corrected, and the HTS code has to be corrected or added? What happens? How does this get corrected?
So you have some choices, and they're fantastic choices. You could actually file a unified replacement to replace the entry and the ISF at the same time. You could file an individual replace of the entry or replace of the ISF separately, as if you had filed them separately to start with. The piece about the bonding is this is one transaction that you're submitting. So there has to be one bond coverage and one party responsible for that information. Lisa, Craig, and I had spoken this past week about this update, but we do provide for replacing all at the same time.
There was a question, say I want to do unified entry, but my entry information isn't ready yet. Can I wait to file ISF at the time of entry or need to do separate?
Separate. Your ISF obligations do not change. They still have to be done that generous 24 hours prior to loading.
And that was Craig answers too.
Yeah. Behind the scenes, that was exactly my answer as well.
Well, actually, this was Craig speaking in Stephen's voice.
Yeah, it's this doesn't change your ISF obligation, and in this case, unified entry or the unified filing is off the table.
We had some other questions too. With unified filing, how would the ACH statement be managed? The statement pay date is generated based on the cargo release date, which will occur well before the cargo arrives.
No, actually. The release date is always updated formally and officially to the whichever is later, release or arrival. Please feel free to pay it earlier. Lisa won't mind either.
Yeah, no, I won't, not at all. There was another question, are entries that require FDA and USDA qualified for unified entry?
Not at this time.
I guess the plan would be by November 2015.
That is up to our FDA and other PGA partners.
Right. There were a couple questions that came in about, customs business. Does the ISF liquidate with the entry since it is defined as customs business? That's actually something Craig is going to have to get back on because it was a question that we had originally asked before, and there's still two different processes from that. ISFs don't liquidate, but we'll look into that, and you'll have a response when we put the written Q&A together. Talk about that one. And then there was also a question, how are carrier IT's V-bonds, in-bond shipments handled?
Those are separate from this. Those are ISF 5s. Is there a specific question in there?
No, that's, it's just things. I guess that's the answer.
There's no impact from this particular process.
And the same with, can you file a unified entry on freight moving in bond?
Yes, but I have to think about whether we're doing that at this time. I don't think it makes any difference.
Because if it comes into the ocean port and moves in bond from there, right, it wouldn't matter.
Right. Technically, it doesn't matter because the ISF 5 is for when freight is moving through the country in bond and not staying.
Correct. Right. Yeah, that's what we thought.
We don't hold an importer to deciding a month in advance or 2 weeks in advance if they're going to clear at the first port or an interior port. That's not part of the ISF.
Okay. And there was another question about quantities in UOM. When you went through the data elements, how come those are not included?
Quantities aren't part of the ISF filing.
So, and it's not required then for part of the release either.
Well, that's a different question. It's not a mandatory element for ISF filing. It is required for the release, but in a very unique way. You can go the traditional route of saying, I'm making entry on 12 boxes for this bill of lading. Or if you leave the bill of lading quantity blank, you are making a tacit declaration of the full manifested bill of quantity. And if that happens to be 12, then you're making entry on 12.
Okay. So we have a few more questions that came in. I guess they're not believing you about FDA, that you can't use Unified for FDA, but obviously that's because in the single window the other government agencies have not been brought in yet.
Yes, so when I made that statement, it's only because the other agencies aren't ready to work inside with ACE cargo release yet. It's got nothing to do with ISF.
Right. And then there was a question, doesn't unified entry include entry summary? And obviously we're just talking about ISF and release here, and one step
For the moment.
Would be a separate.
For the moment, and we are absolutely definitely going down the path where you'll be able to certify from summary for both cargo release and ISF. So yes, if you want to be able to certify from summary for all of that prior to the loading on the vessel, absolutely.
Okay, and there's this last question here, because I think we're at the end of our time, so we'll take this last one. If a shipment arrived in Norfolk and is to be cleared in Chicago, how do you declare the IT in-bond number? So there still seems to be some confusion about this IT side of things.
Oh, well, I've got a little magic going. You can always update your entry with the in-bond information, like a bill of lading update today on traditional entry. And if you don't, we actually have some magic going that when an in-bond is posted against that bill, we recognize it and we immediately notify the filer of the entry of the in-bond information, and we'll even roll the release from the first port to the port of entry, which would equal the in-bond destination port.
Okay.
And we give you all the details, including the date of creation of the in-bond, the port of origin, the port of destination, the piece counts, etc.
Okay, great. And since we started late, I'll take this last question too. What about entries with Lacey Act declarations? Are they currently eligible for ACE cargo release?
Not at the moment.
So pretty much just your plain, can you kind of summarize what kind of falls, anything that doesn't involve a PGA at this time?
Vanilla without much flavor.
Yeah. Okay. Well,
but
I want
to... may I add, it is in production now, and we're looking for people in the 4 pilot ports for ocean to be using it.
There you go.
We haven't had any takers yet.
Yeah. I mean, I keep saying, you know, remember November 2015 is the date, right? So it's not that far away. So a lot of these things are going to be coming down the pipeline for sure. But I think the reason we wanted to have you know, this presentation today is because when Craig and I were doing our outreach, we got a lot of questions about it, you know, this Unified ISF cargo release that we were not equipped to answer. Steve, thank you for joining us today. With a wealth of knowledge, we would not have been able to answer a lot of these questions for sure. And it makes my job easier to have such great experts on the call. And we really love all your questions so that we can have open dialogue with you. So I think we're out of time. And as I mentioned, we'll download all the questions so that you'll get written responses. Most of you have seen these ACE slides before, but they're in here. And the mandatory dates for transition to ACE, as I had already mentioned. We also put in here some information on the ISF reports. Most of you have seen this before. We already answered the question about the delays in the reports. There have been some issues, and you see those CSM messages about that. But please be using these to manage your compliance as best you can. And with that, I will summarize all of our contact information was at the front of the presentation, also here with a summary of a lot of the links. And I think we've answered all your questions already, so we thank you for joining us today. You'll receive 2, actually CCS credits for this session, not CES. And thank you again, Steve and Craig. We appreciate your time and time to answer everyone's questions.
Thank you, guys.
Thank you.
Thank you, Lisa.
All right, bye-bye.